Welcome to MPUNGWE-PUNGWE YouTube channel. Subscribe for you to enjoy more of our videos anytime we upload.
Thank you very much, Chair, Honorable Chairperson, Honorable members, colleagues from the Reserve Bank, members of the media, ladies and gentlemen. First of all, let me thank you for the compliments and also the congratulatory message. I am deeply humbled. Chair, in your preamble, you indicated the things that are to be covered. I can assure you that by the end of the presentation, most, if not all, the things that you said at the preamble are going to be covered. With your permission, Chair, the format of our presentation is that I will make an opening statement first, and my team, led by Director responsible for pensions, assisted by the Director responsible for financial regulation, that is Kaluso Chihana and Sopani Gondwe, will make a PowerPoint presentation. So, Honorable Chair, good morning once again, and allow me to begin my remarks this morning by thanking you and the honorable members of your committee for inviting me in my capacity as Registrar of Financial Institutions to appear before the committee to address you on my office's engagement with the Public Service Pension Trust Fund, specifically regarding the process and the conduct of the Board of Trustees in the course of the acquisition of Amaryllis Hotel. Chair, I'm fully cognizant of the importance of this matter to your committee, to the Public Service Pension Trust Fund, to its members, and to Malawians at large. We are duty-bound by statute to ensure that the interests of all stakeholders are protected. Chair, you may be aware that in 2010, Parliament enacted the Financial Services Act as amended in 2025, which is the primary legislation where I derive my mandate as Registrar of Financial Institutions. We are mandated, among other responsibilities, to promote the safety and soundness of financial institutions, the highest standards of conduct of business by financial institutions, the reduction and deterrence of financial crime in financial institutions, the protection of consumers of financial services and its products, and the stability of the financial system as a whole. We are tasked, Honorable Chair, to oversee the regulation and supervision of all financial institutions in Malawi, which include banks, insurance companies, pension entities, microfinance institutions, financial cooperatives, capital market players, and others. To achieve this mandate, we carry out various activities and processes that include off-site surveillance, or what we call desktop examinations, where the financial institutions themselves submit regular information to us on a periodic basis. We also visit the institutions to kick the tires, so to speak, through what we call an on-site examination or inspection, in which we have the opportunity to interface with the board and management of the institutions. It is, Chair, in keeping with this mandate that we also supervise and regulate the Public Service Pension Trust Fund through regular desktop as well as on-site examinations. The last comprehensive on-site examination was in July-August 2025. The Public Service Pension Trust Fund is one of the 33 pension funds that we regulate and supervise in the pension industry. The pension fund, having been established in 2018, is one of the fastest growing pension funds on the market. And within a space of 8 years of its establishment, it has already grown to be the third largest pension fund in the country. It is therefore classified as a systemically important fund, meaning that its failure can have far-reaching consequences, not only to its members, but to the financial system as a whole. I must mention, Chair, that prior to the recent developments, the pension fund had been managed by a succession of two cohorts of Board of Trustees. The current board is the third in that line. The board began from inception, managed to set a sound platform for the pension fund, which allowed it to grow from strength to strength. While the pension fund broadly complied with the requirements, the major challenges included failure by the employer, that is the Malawi government, to timely remit pension contributions, failure by the pension fund to have audited accounts for a number of years, and erratic governance. These are the key compliance issues that we have been engaging with the pension fund for some time, and engagements continue to date. Now I come to the specific Amaryllis transaction, the transaction that we are here for, but I just wanted to give you the background. At the last on-site examination, we noted through various documentation that was availed to us that the pension fund exercised its mind on the possibility of acquiring the Amaryllis Hotel. The previous boards engaged a number of service providers to assist in the assessment of the viability of the hotel as a going concern. Going through the board minutes, various documents, and also conversations, actual conversations with the Secretariat, it was made quite clear to my office that the board was not in support of the transaction. Having established that, my office did not therefore pursue the transaction, as there was no need, since the board itself at that examination had resolved not to pursue the transaction. Following the expiry of the mandate of the board around September 2024, the pension fund operated without a board until September to October 2025. Partly, this was caused by the fact that the appointing authority withdrew the names of trustees that were to replace the board for reasons that are beyond us. Thus, when we visited the institution in August 2025, the Secretariat officials confirmed to our team of the position of withdrawing the transaction from the transaction. It was therefore surprising that on meeting the new board, later on it expressed renewed interest in the transaction. At this time, Chair, my office simply advised the pension fund to ensure that they follow a due diligence process before making any investment decisions. Due diligence here included financial viability and not breaking the pension law on investments pertaining to life insurance and pension funds. It then came to us as a surprise when my office came across information that the fund was progressing with the transaction at a lightning speed and not commensurate with the size and complexity of the transaction. You see, Chair, from the presentation that will be made later on, that reliance of the decision was made by advice from a firm which only spent 1 day on the transaction, and that's why we described it as a lightning speed. It was against this background that my office decided to intervene in the matter by immediately issuing a direction to stop the transaction. Specific chronology of events and other details will be provided in the detailed presentation, Chair. Honorable Chair, I was appointed Governor and therefore Registrar of Financial Institutions on 23rd January this year, and I was confirmed by the Public Appointments Committee on 9th February. What I have been describing here are briefings and documentations provided by my staff and my understanding of what happened while I was not there. With these briefings, Honorable Chair, and subsequent events, my involvement has been to deal with consequence management of the disobedience as a result of the breach of investment laws and regulations pertaining to the management of life insurance and pension funds, and the apparent lack of due care, fiduciary responsibilities, and questionable governance conduct. As pointed out, Chair, what transpired thereafter was clearly an act of disobedience, where the pension fund trustees decided to go ahead, notwithstanding our directions, and I think almost probably one would say bordering on arrogance. It is therefore in our interest to ensure that we also hear more about the motivation for the trustees to proceed with the transaction, ignoring all the directions that were given by the regulator at the time. Thus, Honorable Chair, on 20th February 2020, that is when I issued my first directive and, among other actions, an order of rescission of the transaction. Chair, we do not take disobedience of our regulations and financial laws lightly, or else you would agree with me that there will be chaos in the system. My office has therefore since moved to impose administrative penalties on the trustees as provided by law and issued direction for the trustees to once again rescind the transaction. Meanwhile, we have engaged the Financial Intelligence Authority to follow the money, investigate the transactions for possible commission of financial crimes. We have asked National Bank and CDH Bank to reverse the transactions, regard the loans as unpaid, and quarantine the proceeds until the process is over. It is also our understanding that FIA, that's the Financial Intelligence Authority, has already frozen some of the funds connected to the transaction, details of which will be provided in the presentation by the Director of Pensions. If we do not receive satisfactory feedback to some of the correspondence to the trustees after due notice, we will impose extra sanctions as provided for in the law. The powers that are vested in us, they include a declaration that the trustees are not fit and proper persons to run a fund, and that the trustees may be referred to prosecutorial agencies for possible financial crimes. And of course, we will revoke their licenses. Chair, with your permission, I will therefore request my team to proceed with the presentation before we can take questions from honorable members of the committee. I submit, Chair. Thank you very much.
Thank you so much, Registrar of Financial Institutions. On behalf of Public Accounts Committee, would like to assure you that we are available anytime, and the route that we've taken is something which is commendable. And as your committee, we are ready to get more details through the presentation as you've guided. I would like to ask the one to present to take to the floor. Thank you so much, Registrar of Financial Institutions.
Through you, Honorable Chair and honorable members of the committee, allow me to take you through the presentation. Picking up directly, I think, from the comments or the remarks made by the registrar. Our mandate extends indeed to all financial institutions, and our key focus is that we promote the safety and soundness of all financial institutions as they operate. That is very important because a financial institution that is not sound may not be able to meet its obligations when they are needed. The Public Service Pension Trust Fund has members who retire in so many years. And it is very important that as they undertake investments, decisions, they must be made prudently to ensure that the funds grow at a reasonable rate of return. And that will ensure that at the time when members retire, they are able to receive their retirement benefits as and when they fall due as the Pension Act requires. So our role is more of an oversight role as the registrar, and we do this in many ways. I recall, I think the registrar highlighted a number of objectives and activities that we do. But let me just zero in on the fact that, among other things, we also do license trustees. So trustees are licensed, and once they are licensed, they are empowered to run the affairs of the pension fund. Among these is actually the power to make investment decisions. So it's important to emphasize on this because the registrar does not make investment decisions for pension funds, but the investment decisions are made by trustees. But in so doing, our interest is to make sure that these investment decisions follow a due process, a governance process that one can look at as being credible. Trustees are therefore subject to regulatory and supervisory oversight by the registrar. Supervisory is the aspect which the governor covered on, that we do off-site surveillance, but we also do on-site examinations. Regulatory is the licensing aspect. And so our expectation is that trustees will comply with the relevant legislation that is there in place, starting from the Financial Services Act, the Pension Act, and the various directives that the registrar has actually issued for compliance by pension funds as well as the trustees. Being the highest governing body in a pension fund, they must set the standard by making sure that they pay attention to the compliance requirements. And this is a minimum expectation. And so, as part of our ongoing supervision, as the governor alluded, in August, specifically starting from 21st July to 1st August 2025, we scheduled a routine on-site examination of the pension fund. The last on-site examination that we conducted at the Public Service Pension Trust Fund was in 2022. The governor mentioned that there are 33 pension funds. And so for us to be able to go back to an entity, it means it takes a bit of time because there are other pension funds that we also have to regulate. And so during this examination, and I think we have provided a copy of the on-site report that we did on this, among other issues, one of the major findings that was really key was the fact that we had noted the substantial payments that had been made in the pension fund in the absence of a board, an active or functional board. I think we will be able to provide sufficient detail in terms of what actually happened for the pension fund to appear to be operating without a board from September 2024 to September 2025 or thereabouts. But this issue was a concern to us because ordinarily they would have been expecting that these payments that were to be made would ordinarily be approved by a board, but they were being done under the stroke of the pen by the principal officer. So, and then there were concerns around the governance of the pension fund, obviously because boards were being licensed, but somehow they were not functional. And then there was the communication that we had with the pension fund until when this current board was now in place. So having these issues of concern, because they concerned the principal officer, it was very difficult for us actually at that time to raise that issue of payments with the principal officer. We needed to meet the board. And through our assessments, based on the records that were there, the minutes, and also conversations with the Secretariat personnel, the Amaryllis transaction had been considered a number of times. But it was almost conclusive that the boards had reached a point where they were actually withdrawing. They withdrew essentially from the transaction. I think there are minutes of a meeting that was held in June 2024, where this issue was also discussed. So at this point in August, this new board was not yet functional, although it had been already licensed by the registrar in June 2025. We did not discuss, we could not hold, let me take that chair. We could not hold the exit meeting. So once we have done the on-site examination, what is involved is we go on-site to the entity and we meet the respective personnel, we get documentation, we go through them. Once we have concluded, we come up with a report, and that report we submitted to the board, and then we hold an exit meeting where we discuss these issues. Now, we could not hold this exit meeting with the principal office. That's why we scheduled a meeting with the board. I will come back to that. But before we could do that, once we had actually agreed on a date of 5th November, where we're going to exit the examination, on 3rd November, we received whistleblowing information on allegations that there were governance lapses on the acquisition of Amaryllis Hotel. The information pointed to the fact that the board chair had actually presented, I think he has a legal background, he had presented to the board the threat, the legal threat that was there, that the Use of Investments Limited were going to sue I think apparently there was a meeting on the 2nd October 2025 that took place where these issues were discussed. And at that meeting, it would appear there was a resolution that the pension fund must seek legal opinion on the issue. And that legal opinion was sought. And in conclusion, the opinion gave the pension fund an 80% chance of actually winning the case. However, on the 25th October 2025, there was an extraordinary meeting of the board where a number of resolutions were made. The suspension of the principal officer, the previous principal officer, the secondment of a new PO, principal officer, and also that there was an authorization of acquisition of Amaryllis Hotel, and that the investment committee had been assigned to map the way forward. Chair, at this point, we still revert to the fact that the mandate of making investment decision lies with the board. And at that point, when we received this information, our interest was to understand how the due diligence processes were going to proceed from there on. And based on the information that had been shared and also what we have received subsequently, we could not establish whether the board, in making their decision, they considered this legal opinion that was actually sought. And so what we did was we arranged to obtain more information, to meet with the whistleblower. We continued to review the information. And the whistleblowing information at this point did not disclose a price, or that there was something or anything that had been negotiated at this stage. So there was nothing necessarily what we would call alarming at this point, because we expected the pension fund to fulfill its mandate of making investment decisions in a due manner. And so when we were holding the exit meeting on the 5th, with the new board, we could not discuss the issues that the whistleblower had provided to us because it was still fresh and we were still digesting and analyzing the information. We focused on the issues that the examination had actually assessed. But among the issues that the board advised us in that meeting was that there was renewed interest in the acquisition of Amaryllis Hotel. And because of that, we did advise them in that meeting that we expect you to follow a due diligence process. And by this, I think the issues that have actually been highlighted in terms of when you look at the due diligence process, if you look at the processes that had been conducted by other investment managers that were involved in the process, that is the sort of process that we were expecting would happen. So we went back to base to prepare our on-site report and also continued, obviously, to analyze the information from the whistleblowing. On 14th November, we received further whistleblowing information. And in this information, there was an allegation that the process is moving at a very fast pace. Just to highlight, based on the information that we received, on 11th November, the pension fund finalized the procurement process. On the 12th, they held contract negotiations with the consultant, and on the 14th, the consultant produced a report. And in there, it was showing a price range between 115 billion kwacha and 145 billion kwacha. That's the range which the consultant actually indicated. And there was also information that the investments committee and the board, I think the board will meet on the 19th of November. But prior to that, there may also be a meeting for the investments committee. So when we received this information, we were, I would say, maybe shocked to discover what is going on. And this was on the 14th, late afternoon. I think I should just say in the afternoon. And so immediately, we engaged internally and agreed to issue a restriction, a direction to stop the transaction because we were concerned. Why were we concerned, Chair? Is because when we looked at the amounts that were being mentioned and we take into account the investment profile of the pension fund, it was clear to us that if this investment was going to proceed, which was going to be an acquisition of an unlisted equity, it would have meant that the pension fund was going to breach our directives, which set prudential limits on investments for pension funds. As the governor said, we do not take breaches of our regulations lightly. And with this in mind, we immediately, as I said, issued the direction of 14th November. With the information that the pension fund had scheduled a meeting on the 19th, in that letter, we also requested for a meeting on the 18th. Because our thinking at that point was that in the meeting of the 18th, we were going to buttress our point to say that do not proceed. Of course, just to highlight that if the investment had also proceeded, for example, in 2023, at 47 billion, at that point, the pension fund had assets totaling 338.4 billion kwacha. It would have meant that this was going to be 21%. The only caveat is that in 2023, we had not yet issued this directive that we're referring to. But clearly, we're still going to be uncomfortable with the level of investment in unlisted equities. So unlisted equities are considered also to be a high-risk investment. So as I mentioned, on 14th November, the registrar issued a letter to the Public Service Pension Trust Fund Board, directing them to hold all the transactions related to the acquisition of Amaryllis Hotel until the direction is either varied or removed. And we did request for a meeting. The pension fund requested for us to change the meeting from the Tuesday 18th, November 2025, to Wednesday, November 19, 2025, which we accepted. And so on the 19th of November, we met them in Salima at Sunbed Livingstonia Hotel because they had already scheduled their own meeting and they requested us to meet them in Salima. At the meeting, Chair, when we inquired about the transaction, we were shocked to learn that the pension fund had actually signed a sale agreement. Let me underline, Chair, that what surprised us the most was to hear from the chairman that some of the trustees were actually not yet knowledgeable of this fact, that the sale agreement had been signed, meaning that some of the trustees actually got to know about the signing of the sale agreement at the same time as we were learning. This to us signaled problems in terms of governance. And so we requested, beyond that, that the board should submit documentation relating to the decision-making process that they had engaged in considering this. And because we also wanted to confirm whether this had passed through the board decision-making processes which the pension fund has. And I must underline, Chair, that in this meeting, at no point did we insinuate or suggest that the position of the registrar of the letter of 14th November, which was actually signed by the registrar a few days before, that the position had actually changed. The registrar would communicate that sort of decision in writing. Once we requested them to submit this further information, because we really, as I said, we wanted to appreciate what had actually gone on the 24th of November, we received the submission from the board. And we have also shared, we submitted to the Secretariat the information that we had received from the board. On the 11th of November, or I should say a few days prior to that, sorry, Chair, let me take you back to say that on the 19th of November, 2025, when we had met the board, I think it is also the same day that the Malawi Law Society issued a press release. And so there were a number of issues that followed from that. And in December, the Attorney General invited us to a meeting, invited the registrar to a meeting. This meeting was held on the 11th of December 2025, and in attendance was myself, Kaluso Chihana, Director for Pension and Insurance Supervision, Dr. Sopani Gondwe, Director for Financial Sector Regulation, and Director Agnes Sentala, Director for Pension Compliance Compliance and Support. At the meeting, we updated the Attorney General on the registrar's reservations on the transaction, and he did request us to share with him a copy of the analysis report which we were undertaking of the transaction. And this was subsequently shared with him. On the 23rd of December, having now done the assessment, we issued another letter in which we recommended against proceeding with the acquisition based on the information that we had been shared with. And we also directed, in addition to the directions that were still standing on the letter from the 14th of November, that if indeed the board wanted to proceed with the transaction, then they must submit to us a comprehensive justification of the investment proposal, including the viability and also how member funds would be safeguarded should the board want to proceed with the transaction. Just to underline, our direction of 14th November 2025 was neither varied nor removed. So our expectation at this point is that the board is attending to the issues that we had requested them to. And on 2nd February, they submitted a letter to the registrar. And this submission, in summary, was insisting on the viability of the acquisition based on advice from EMJ Advisory. I must say, Chair, that at the time that we were writing our letter of 23rd December, we had actually done an assessment, a review of the EMJ report. And there are issues that we picked from that analysis. I think key among them is the fact that the financial statements that were used for 2021, 2022, 2023 were audited, but 2024, 2025, they were management accounts. Looking at the process of procurement that happened, the time the contract award was done, at what time did EMJ obtain these management accounts and conduct a thorough analysis that would inform the projections, the appraisal that EMJ had done? We could not be convinced otherwise, Chair. And notably, in this communication, we also noted that the sale transaction had actually been executed by this time, before the registrar could either vary or remove the directions of 14th November and 23rd November. Our expectation was, if the board wanted to proceed, remember in our letter of 23rd, we had indicated that they should submit to us prior to that, they should submit to us a comprehensive report. But this was not done. So, on 20th November, just to highlight, Chair, that around this time, we were also transitioning in terms of our leadership. And so we needed time to brief the new registrar and also for him to apprise himself of the issues that we were analyzing and dealing with. After his approval by the Public Appointments Committee, we engaged, and on the 20th of February, the registrar, in line with the sections 39 and 75 of the Financial Services Act, issued a direction to the board, or administrative penalties to the board, to show cause why trustees should not be penalized for not complying with the registrar's directions.
Welcome to MPUNGWE-PUNGWE YouTube channel. Subscribe for you to enjoy more of our videos anytime we upload.